Mr. Arneson, we're going to let you and Mr. Miley go first.
Thank you, Mr. Chair and members. It's a pleasure to be here tonight. Ms. Maloney has indicated that she's not going to ask for any additional sympathy given her bad cold. I want to introduce myself a little bit to the board. My name's Roger Arneson. I'm a lawyer. I represent the State School Principals Associations. I represent 1,700 school principals throughout Minnesota. I represent the Willmar principals as well, and Mr. Miley. I've represented the Willmar principals for a long time. I used to have a lot of dealings when Ron Erdman was the principal out here, and so we're happy to be here. And let me say, I would much rather be here talking, as the superintendent referenced, about iPads for the middle school than about a grievance. This is serious business, and we're in kind of an interesting limbo here, because if we advance this grievance to such a level that it's resolved in our favor, it becomes confidential and private data. Final discipline is public, but there is no exception at this level to do these in a closed meeting, so we end up doing this here in a public meeting. And given that, and Ms. Maloney and I have talked about this, I plan on a rather abbreviated discussion with you here tonight. The principals have a collective bargaining agreement that has a 3-step process. The first level is with the superintendent, then the second level comes, it appears to you, it says school district, but we assume that's the board. And then the level after that is arbitration. While this is listed as a quote hearing, in a general sense, it's kind of a blend of hearing and appeal. The first level of this was brought to the superintendent, and that appeal was denied. So this arises out of an employment circumstance that Mr. Miley's wife was hired by the district, and some of the communications that took place or did not take place as the result of that hiring. And there's an allegation that some of Mr. Miley's communications in that process were inappropriate. We dispute those allegations. We think those allegations are false. Some of the documents that are involved in this include an email that went to a former board member and then a response from that board member, and Ms. Maloney has advised me that she has that board member here to talk tonight. I'm not sure what documents you'll be presented with, but these are documentary pieces as to what the communications were between Mr. Miley and this board member. And I'm looking at an email, and you can put this in the context of when the board member speaks, but she actually responded to Mr. Miley and said, "Thanks for the information. I'll keep this in my file, Sandy." What we're looking at here is to have the disciplinary letter that was sent to Mr. Miley. I'll pull this here and give you the date. October 23rd, 2012. We're looking at that to have that expunged from his file. I have no question in my mind that superintendents have the authority to direct the work of school principals. And the superintendents can say, this is how we want you to do something in the future. And that those directives are not grievable. I think that's within the purview of the employer to direct the work, the same as when principals direct the work of teachers and on down the line. But when the administration characterizes some of the activities as inappropriate, then that comes into challenge. And we think the discipline here that's been put out in this letter is inappropriate, and it's not connected to the overall facts of the circumstance. Let me be frank. When I appear in front of boards, I'm rarely able to overturn the recommendation of the board's lawyer and the superintendent. There is a long-standing practice of protocols about backing up superintendents, which makes sense. I think that's why you've hired superintendents. But from time to time, mistakes are made, and this happens to be one of them. You do have the opportunity to end this matter now. It is within your jurisdiction to do so, and we would urge you to pull this letter. I think certainly the superintendent could recraft directives to Mr. Miley that would not be grievable and not go down this particular road, and that is what we are recommending that you do. Given that we hope at some point that this matter would be resolved in our favor, I'm not going to have him testify tonight, and I mentioned that to Ms. Maloney as well. I really just don't think would work real well in this particular setting and what record we want to make. And a lot of this is documentary. I'm not sure how much of it you've been privy to, but as I said, we think you can end this. We think it should be ended. And I want to circle back to where I started about we'd rather be talking about iPads. I think Mr. Miley's been here a long time in the district, 17 years. He enjoys a good reputation. That doesn't mean that superintendents and principals can't have some disagreements from time to time, but we think the discipline here that has been put in this file is very severe and that it's inappropriate under these circumstances, that it would have a long-term chilling effect on Mr. Miley. And for that reason, we've taken this extraordinary step to come here tonight and ask you to pull it out. So, Mr. Chair, that's the extent of my presentation.
All right. I think we'll go to Mrs. Maloney, and then after we hear the district's concerns, we'll come back, and if we have questions as a board, we can direct them to whoever we want to direct them to. So, Ms. Maloney.
Thank you very much. I apologize for being hard to hear tonight. I actually feel a lot better than I sound. Roger carefully pointed out that this is a unique situation. Under the Minnesota Government Data Practices Law, a disciplinary letter is private data until the grievance process has been exhausted. So we cannot release the disciplinary letter to anyone other than someone who has a need to know, such as board members, because you serve at the level 2 grievance hearing. But the open meeting law, Minnesota Statutes 13D.05, requires that, except as provided in this chapter, meetings may not be closed to discuss data that are not public data. So we're in a dilemma. We're going to be discussing an open meeting content of a letter where the letter itself is private. So that does make us a bit more circumspect about what we're going to talk about today. But I want you to understand that under a grievance, the employee has what's called the burden of proof. If they receive a disciplinary letter that they think is unfair or that the district didn't have just cause to issue it, they have the burden of proof of bringing to the board evidence to show you why that letter was unfair, why it was false or inaccurate, or there wasn't just cause. And clearly with the very general statements that were made tonight, you haven't heard that kind of detail. What I'd like to do today is just present a brief opening statement and then call just one witness to highlight the administration's concern about what occurred in this case. As we are so painfully aware, we have been under a long and deep recession in this country, and jobs have been hard to find. Now, in the public sector, certainly high-level administrators or board members, they are entitled to have members of their family apply for jobs in the institutions they serve, provided they are qualified. But once a family member applies for a job, it is incumbent upon that high-level official to avoid any appearance of a conflict of interest and not advocate or do anything to advance their spouses, their sons, other relatives' ability or friends to get that job. Because we want to have a level playing field for all the applicants for jobs in the district, especially at a time when jobs are so near and dear, especially good jobs like this with high wages and benefits. So last summer, the school district posted a job. This would be a full-time position for the family and community liaison position at Kennedy Elementary School. When the job was initially posted, apparently whoever did the posting wasn't aware that it was grant funded. Now, when we have positions that are assigned to a specific building, normally the principal in that building develops a team, and they go through a standard process for hiring. They review the applications, They designate which ones they think are the most qualified of the applicants, determine how many they will interview, and then have a group interview for those, what we'll call the finalists. Well, that initial round of interviews did occur in this case, and Mr. Miley's wife was one of the individuals interviewed for the position. But before an offer of employment was made, it was recognized at the district level that this job was grant funded. And it really needed to be hired at the district level because it was the district administrators who are familiar with the requirements of the grant. Because although this person would be an employee of the school district, we still had to make sure we complied with all the requirements of that grant for the position of being the community liaison for Kennedy School. So in light of that, they decided to re-interview the finalists. And another interview committee was formed, and a second round of interviews did occur. Well, between the time that the position was posted and the time the final interviews were occurred at the second round at the district level, evidence would show that Mr. Miley contacted the new principal at Kennedy and discussed his wife's application for the job, and that when that final decision-making to fill the position was transferred to the district-wide committee, he contacted one or more board members, once again to discuss his wife's application and complain about the fact that it turned into a two-step interview process. It's the administration's contention as inappropriate, it's a conflict of interest, it's unprofessional, it's an abuse of power to try to help your relative get a job with the district. And so, as its only witness for tonight's level 2 hearing, we'd like to call former school board member Sandy Euchre. Sandy, I don't know if you know all the new board members.
I do.
Well,
But you didn't expect me back so soon.
she didn't even get one night off yet. Sandy, how long have you served on the Willmar School Board?
Well, 15 years.
And did you know Mark Miley, the Grievance, prior to becoming a board member?
15 years ago, maybe. We've been neighbors. We've lived in the same neighborhood for a long time, so probably a year or so before. Yeah, we've been friends a long time.
And so you know Mr. Miley as a neighbor as well as a principal, one of the top executives in the district.
Mm-hmm. Yeah.
And prior to August of 2012, did you have communications with Mr. Miley about issues related to the school district business?
In a professional setting, I'm a school board member, he's a principal, so we would have,
And so would he call you from time to time about school issues?
No, but if we ran into each other, how's it going, how are things going? Yeah, just in general, but no, not phone calls directly regarding issues, I guess, but a professional relationship if we ran into each other in the community, yeah.
Were you aware that in the summer of 2012, the school district had posted a position for a family and community liaison officer at Kennedy Elementary School?
I knew they were interviewing for the position, yes, but I was not involved in the interviews.
And are you typically involved in interviewing for positions at the level of a community liaison?
No.
Is that normally done by administrative staff and teachers?
They have an interview committee.
Were you contacted by Mr. Miley in connection with this vacant position?
I was contacted. He wanted to discuss with me the fact that his wife Minnie had interviewed for the position, and she had not heard anything in return from Todd Goglai, who is our principal over there. Minnie had not heard anything. Mark had talked to Todd, who, from my recollection, had informed Mark that Minnie was a top candidate, but they had not yet decided who would get the position. Mark expressed some frustration over the process, but he did not ask me to do anything to intervene.
And how did that communication occur?
He would call me on the phone, and I think He talked to me about it. I know he also mentioned that he spoke with Mike Reynolds about it. And he would usually call me in the morning. That's when we usually talked. After, I think, 3 or 4 discussions, I asked him to send me an email with the facts because I was getting a little confused. There were several contacts made with Todd regarding Minnie's employment, and so I wanted to make sure I had things down correctly. And it was probably after a couple of weeks that Mark and I had been talking that I asked him if I could forward his email to Nate, our board chair, because I couldn't do anything on my own, that if we wanted to look into the situation, I wanted Nate to be involved in it. And so I had his permission to forward that email, and that's what I did. And from that point on, Nate took over.
From your statement, it appears that you were concerned that Mark Miley, the grievant, was contacting Todd, the new principal. Why were you concerned about that?
Well, I just felt that it was Todd's position to hire, and that Mark is one of our senior administrators, our principals. I thought that it was a undue influence on Todd, and Mark actually had, a financial gain to be had here with his wife being employed by the district, and so I thought it was a little bit inappropriate that he would try to influence that. So I guess that was my concern in thinking that maybe we should get Nate involved and see what was transpiring, because I was only hearing one side of the story from Mark, and obviously there's a district side, and I was not involved in the interview process. And so I thought maybe Mark was upset, and he told me that he felt like he could sue the school district. And so I called Nate and said, we might have a problem here, because Mark is feeling like we're discriminating against Minnie. He specifically said we were discriminating on the basis of their income. And so, and that he felt that she was maybe being looked over for that reason.
How did it make you feel as an elected official to have one of the top administrators calling you, advocating on behalf of his wife being hired for a position in the district?
Well, it was uncomfortable. I thought it was inappropriate. And it was at that point that I got Nate involved.
I have no further questions for Sandy. Board members, let's all rest my case because it looks like Roger wants to say something.
Oh, can I ask her a couple questions?
Sure you can.
Okay. Ms. Maloney and I have worked together for a long time, so we actually kind of like one another.
And Mark and I have worked together for a long time, and we like one another too.
Well, it's pretty apparent that everybody in Willmar likes everybody else. I mean, I think that's what I was drawing from this. But Ms. Unger, as you know, I'm Roger Arnson, and I'm Mr. Riley's. I wanted to just ask you a couple questions on the sequence of this, and to see if your understanding is the same as what mine is. But my understanding is that Mr. Google Eye, is that the right way to say that?
Goggle Eye.
Goggle Eye? That must just be misery for a school person. Yeah. Yeah, there you go. That he was part of a set of interviews in mid-August where there was an assumption that they were done. Is that your understanding as well?
I wasn't involved in that part of it, so I did not know if they were done or not.
Okay.
So I knew that Mark told me they hadn't hired anybody yet.
Is the sole source of information that you have on this Mr. Miley?
Until I turned it over to Nate, it was, Mark did not want me to do anything. He just wanted me to know.
Right. What I'm asking you is, I mean, did you talk to the superintendent? Did you talk to Todd? Did you talk to anybody else
I
about
did
this?
not. The first contact I had was with Nate.
All right. And I wrote down that in response to one of the questions from Ms. Maloney, you said, Todd did not ask me to do anything to intervene.
No, Mark, excuse me.
I'm sorry, Mark. I
yeah.
wrote Todd here, but Mark did not ask you to do anything to intervene.
Not on the initial phone call. He said, I just want to talk to you. But after 3 or 4 phone calls.
hang on here with me for just a minute.
Okay.
I wanted to make sure that I wrote down exactly what you said. So during the first phone call, he did not ask you to do anything to intervene.
Specifically, no.
All right.
I just was under the
Then-
impression that he wanted me to listen.
Okay, and then you indicated next, as I was writing this down, that you asked him to send you an email to set out the facts.
Well, this was after
Right?
like
I mean, is that
3 or
right?
4 no, this, not on the first phone call. After 3 or 4 phone calls
Right.
with him, I said, we talked about different things every day. I was losing the progression of how this was going. So I said, could you please send me an email and tell me what has happened? So he sent me an email, and I did not forward that to Nate until I had his permission to do so.
I got that.
Okay.
Okay?
Yeah.
So, there's a phone conversation, there's multiple other phone conversations. You say put it in an email, and, is this the email? Is this the text to the email? I assume you have this, man.
Oh, yes.
Yep.
Is that it?
Yep.
Do you need to compare word to word? Is asking?
No, I think I can identify that as being the same. We've looked at it a few times.
Yeah.
Okay, yeah.
Okay, why don't you put that one in front of her? I'll
Yeah.
put this one. Does this email ask you to do anything on Mr. Miley's behalf or on his wife's behalf?
No.
And do you know of anything in writing where Mr. Miley said, intervene on my wife's behalf and hire her?
Not in writing. This is the only writing that went back,
Okay.
This is the only thing I've received from him.
And in fact, you testified here that you felt uncomfortable and you thought this was undue influence, but you didn't say that back to Mr. Miley, did you?
No, I did not.
You sent him an email back that said, thanks for the information.
Right.
Okay. Yeah, that's all I have.
Okay, thank you.
I have a couple follow-up questions. After the first phone call, did Mark Miley ever ask you to do anything in regard to his wife's application?
No, but after 3 or 4 phone calls, I was getting the impression that, when he said that he felt that there was enough information there that he could sue the school district, I said, well, I think, if we're going to proceed any further, I need to bring Nate in on this. And so that was what I did, and then Nate took it from there. So,
Did you make an inference from him calling you 3 or 4 times about his wife's application for employment with the district that he did want you to do something?
well, I started getting that impression, yeah. So,
And did that make you uncomfortable?
well, a little bit. I guess, in retrospect, it would have been nice had he gone to Dr. Kiergaard first. That would be the steps to follow, rather than going straight to a board member. So I would have hoped that he would have discussed it with Dr. Kiergaard first. So,
Based on your 15 years' experience as a Willmar school board member, what should an applicant do if they have concerns about a hiring process?
well, normally the applicant should contact the principal of that building who did the interviewing and find out the status of their interview, their application, the employment, that type of thing.
But if an applicant's spouse felt like they should do that on the applicant's behalf, who should the applicant's spouse contact if they're concerned about how the interview process is being
Really,
conducted?
it shouldn't be the applicant's spouse that does that. So I would say that we would have the applicant contact the principal. I don't think our principal would discuss that with the applicant's spouse, or should not discuss that with the applicant's spouse. That wouldn't be correct.
And so what would you perceive to be the normal chain of command that the applicant would follow if they were concerned about being treated fairly or the status of an application?
They should contact the principal in charge of that building, the interviews, where the interviews were conducted.
And if they weren't satisfied with the response they got from that person, would they have who would be the next person in the chain they should contact?
If they weren't satisfied with the principal, then I would say they could come to the administration here, which would be Dr. Kiergaard or Liz Fisher. She's in charge of our human resources.
As the Human Resources Department in charge of basically all hiring?
Yep.
And were you aware whether the applicant had contacted either Liz Fisher, HR, or superintendent in regard to her concerns about the process?
I was not aware of that.
And all your information came from Todd?
No,
I'm
didn't
sorry,
talk to
it came
Todd.
from Mark Miley.
From Mark, right.
I don't have any more questions for her.
Okay.